freedom of speech,
fundamental rights,
freedom of conscience,
academic freedom,
freedom of press,
and the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights in Education.
Welcome back to So to Speak, the free speech podcast, where every other week we take an uncensored look at the world of free expression through personal stories and candid conversations. As always, I am your host, Nico Perrino, and I'm joined in FIRE's DC office today by the regular So to Speak guest, Ron Collins. Ron, welcome to the show.
It's great to be back, Nico.
Yeah, I should say welcome back to the show. For those of you who haven't heard one of our previous episodes with Ron, he's got a long list of credentials. He's the co-director of the History Book Festival, which is a new festival, correct?
We're coming into our third year in Lewis, Delaware.
And before that, you were the former scholar at the University of Washington School of Law.
That's right.
You are the current editor of First Amendment News, which is now living on FIRE's website.
Yes.
And which you can register for First Amendment News to receive it in your email on our website.
Right, and it's free.
Free, and it's one of the best resources out there for information about the First Amendment. He's also the author of many, many books, including the forthcoming First Things First, a course book on free speech fundamentals.
Yes, and it's, I think, the least expensive college textbook. It's an ebook, and it'll be under $5, replete with hundreds and hundreds of audio and video links.
And we don't have the release date for that yet, right?
Coming soon, very soon.
Very good. He is, as I said, also a regular guest on the show. We've discussed many things from like the Espionage Act to Lenny Bruce to what were you on here last time discussing?
I think The People versus Ferlinghetti.
Yes, which is your most recent book.
That's correct.
Well, Ron, thank you for coming on the show again today. I want to talk about one of your most recent pieces of scholarship. It was in the FIU Law Review. What is that? Florida
International University Law Review.
And it's called Thoughts on Hayden C. Covington and the Paucity of Litigation Scholarship. So Hayden C. Covington, a name I hadn't been familiar with before. I imagine from the title of your article, not many people who work in First Amendment law are familiar with. But let's just go over some of his accolades.
Yes, but just before we start, the vast majority of professors in college and in law schools who teach constitutional law and who teach First Amendment law, the vast majority, I would say 98%, maybe 99%, maybe 99.5% have never heard of Hayden C. Covington. It's amazing.
And it's amazing for these reasons. He argued 44 cases before the Supreme Court of the United States, and he won 85% of them. During 1 week in 1943, he argued 14 cases before the United States Supreme Court, which I don't think the Supreme Court hears 14 cases in a given week anymore.
Now, in actuality, some of those cases were combined.
Okay.
But still, I mean, even 4 cases is a major deal.
Even 2 cases in 1 week, unless you're the Solicitor General, is pretty incredible. He's responsible for a lot of the doctrine that are just a regular part of the First Amendment today, including the incorporation doctrine. He's responsible for that. The state action doctrine as applied to the First Amendment, the preferred position doctrine, and the least restrictive means doctrine. And he had a success rate before the United States Supreme Court higher than any man except former NAACP attorney and subsequent Supreme Court Justice Thurgood Marshall.
Right, and that's only because Thurgood Marshall argued fewer cases. So if you actually looked at the same number of cases, you might have equaled or even surpassed him. There's one thing I don't know if you have in terms of what you're thinking about, but when he argued cases in the Supreme Court, he would come in a bright green suit with padded sleeves, a plaid red tie, and he would almost scream while he was speaking and never let a justice interrupt him at all.
Yeah, he was kind of a outsized figure, it seems. 6 feet tall.
Right.
And he liked to work the media, from my understanding as well.
He did. And he also was somebody who literally and figuratively rarely passed up an opportunity for a fight, whether it was in a courtroom or on the street.
Yeah, he worked 18 hours a day.
Right.
Workaholic. And so...
And then toward the end, he represented a famous boxer in a trial.
Yeah, someone named Muhammad Ali.
Well, he was then Cassius Clay, but yeah, Muhammad Ali he would represent. Yes.
And he didn't represent him quite well, according to your article, but we can get to that.
Right, okay.
The Supreme Court cases aside, he also had 100 decisions handed down by various state Supreme Courts and also triumphed in dozens of lower court rulings.
Yeah, and sometimes in one year, he alone would be handling as many as 50 cases in state courts and federal courts. I mean, it was just, the man was a machine.
Why haven't I heard of him?
Well, first of all, where did he get his clients, right?
Yeah.
I mean, so he had a client pool that just for years and years and even decades was the ideal pool for bringing cases to the Supreme Court. He was the lead counsel for the Jehovah's Witnesses, all right? And the Jehovah's Witnesses have if you take the Jehovah's Witnesses out of the constitutional equation of First Amendment law, you lose a big chunk. So a lot of our First Amendment freedoms today are based on cases involving Jehovah's Witnesses. And of course, in the 30s and the 40s and the 50s, the discrimination against the Jehovah's Witnesses was just over the top for any variety of reasons, which we'll get into. But in any event, for a good number of years, Hayden Covington was their lawyer. And so that's where he, I don't think he ever argued any cases in the Supreme Court that did not involve Jehovah's Witnesses.
Who are the Jehovah's Witnesses? I mean, you talk about how they were very controversial, particularly in the first half of the century, but even, into the 50s and 60s. I know them. I'm sure many of our listeners know them as sometimes the friendly people who knock on your door.
They are, and they were. I mean,
they're pacifists.
So yes, which didn't win them much favor in the Second World War because of the tenets of their beliefs. They objected to saluting the flag and standing up and saluting the flag. This was a sincere tenet of their beliefs. And that their only loyalty was to Jehovah. They didn't believe in the Trinity. They didn't believe in the afterlife of the soul. They didn't believe in hell. So in that respect, they were seen as heathens. They were rather critical of the Catholic Church, so there was that as well. And they were seen as unpatriotic, particularly at the time of the war. And one of their cases that found their way to the Supreme Court, and this one Hayden Covington did not argue, it was in 1939, the flag salute case involving the Gobitis case that was argued in the United States Supreme Court, and they lost. And
8-1.
Yeah, 8-1. And after that case, the discrimination and hostility toward the Jehovah's Witnesses was just beyond description. I mean, they were being rounded up, they were being mugged, they were being clubbed, they were being prosecuted and persecuted. I mean, it was so bad that Francis Biddle, the then Attorney General of the United States, went on a national radio address and urged Americans to be more tolerant and to end this reign of terror against the Jehovah's Witnesses. I mean, it had really ratcheted up, particularly after that Gobitis case.
Yeah, you provide a lot of statistics in your article about the violence that was brought upon Jehovah's Witnesses. And you write that between 1933 and 1951, that's less than 20 years, there were 18,866 arrests of American witnesses and about 1,500 cases of mob violence against them. Often, they would be arrested because other people were violent against them. They were seen to have incited the violence, and that actually led to some Supreme Court cases. There was an argument in Connersville, Indiana, where Hayden C. Covington and a co-counsel argued on behalf of Jehovah's Witnesses in that town. And Hayden Covington had to go catch a plane, I think, to Maine,
right,
or to Boston, somewhere in the Northeast. And after the argument, there was a mob of people who were looking for him and his co-counsel because of their representation of Jehovah's Witnesses. And we should also mention that Covington was a witness as well.
Oh, yes. And I mean, I believe he had converted years earlier, but yes, he was a witness. He carried a baseball bat in his car as a means of self-defense. I mean, it was that bad. I mean, there were situations where he was literally moments ahead of being murdered.
Yeah, in this Connersville case, he writes, "I went to catch the airplane in Cincinnati and out of Connersville." And then brother Victor Schmidt, who was his co-counsel, he writes, he's dead now. And he's dead with his wife because they were mobbed by a crowd. And as they mobbed them that night in the darkness, after the case in Connorsville was over, they were screaming and yelling that they were going to kill me that night. The Lord delivered me, Covington writes, at the right time, and I would have been killed that night.
I mean, there's photographs of Hayden Covington and his face all beat up and black and blue and what have you, of course. But there's also records from the time he said, well, if you think I look bad, you should see what happened to the other guy. And I mean, I think at one point he said, one time I got a triple against a guy, meaning he hit him in self-defense with a bat. I mean, the Jehovah's Witnesses were very polite. They usually were very well dressed. They wanted to pass out literature involving the Jehovah's Witnesses. I mean, there were cities in the United States that had signs as you entered the city prohibiting Jehovah's Witnesses from entering the city. I mean, literally naming them as a group, and it was that bad. Mm-hmm. And the hostility toward them was, as I said, incredible. But particularly during the war in 1939, that children, school children, would not, because of their faith, salute the flag, all right? In other words, bear false witness. I mean, the only person or entity that you salute or stand for is their Lord, Jehovah. I mean, we may have differences of their views. We may not think much of their religion, all right? But the sincerity of that religion cannot be questioned. And in a country that was, at least in terms of the way it was constituted, was built on religious toleration, what was going on against the Jehovah's Witnesses was really in blatant violation of the very principles upon which this country was founded in terms of religious freedom.
Yeah, so enter the Watchtower Society, which I guess is the organization or group that was created to defend the rights of the Jehovah's Witnesses. And Covington wasn't the founder of that organization, but he was a member of it. He was the lead counsel, became the lead counsel for them, and they developed a strategy to essentially protect Jehovah's Witnesses' First Amendment rights, and as a consequence of that, to protect all of our First Amendment rights. I mean, our First Amendment rights were built upon these Jehovah's Witness cases that were brought by Covington and the Watchtower Society.
Well, absolutely. I mean, we hear a lot about, and rightfully so, about Thurgood Marshall and ACP and the strategy they used to bring cases to the federal courts and into the U.S. Supreme Court.
And Ruth Bader Ginsburg with women's rights.
Right. But Hayden Covington was doing the same. I mean, they actually had pamphlets that they produced, that Hayden Covington and others produced as part of the Watchtower group, that they gave to Jehovah's Witnesses, telling them their legal rights, what they could and couldn't do. They would pick communities where they wanted to challenge the laws. They would orchestrate what they should and shouldn't do. Always very polite. I mean,
except when they're calling the police goddamn racketeers.
Right. Yeah.
We can get into the Chaplinsky case.
Yeah, that did happen. They did, at least a few of them. I mean, by and large, they were very, very civil people and very polite. Obviously, there's exceptions, particularly when you find yourself in the heat of the moment, as in the Chaplinsky case. But there was this strategy, and it was very well orchestrated across the country, and Hayden Covington played a major role. So when the cases were fed up through the federal courts and the U.S. Supreme Court, they had pretty much been vetted in terms of the kind of factual record that they wanted to bring to the Supreme Court. So we can get into it later. I mean, Hayden Covington won a lot of cases. I can't say that he was the Lawrence Tribe or the Paul Clement of his time, because as a Supreme Court advocate, he wasn't necessarily very profound. But in terms of bringing the right cases at the right time to the right court, he played a very significant role.
Well, there is kind of a discussion as to, and this kind of gets into the whole theme of your article, there's a question as to whether advocates before the Supreme Court really make all that much difference, or whether the justices have kind of already decided how they're going to approach a case when the case comes before them. Maybe they read the briefs, but at least oral argument, there's people say you can only lose a case.
Yeah, I mean, let me put it this way, but cases very much depend on the factual record brought before them. That judges have no control. I mean, Supreme Court justices have no control over. So that factual record, which is really pivotal, which is really, if you will, foundational, I should say, that in that regard, he played a very significant role. And, he, in the various cases, it showed that both politically, religiously, and constitutionally, the Jehovah's Witnesses were victims and had been victimized time and again with wild abandon. And so in that regard, Hayden Covington plays a very significant role.
I want to talk about some of his cases. Let's start with the flag salute cases. And to do that, we need to start with Gobitis, which wasn't necessarily his case, though he worked on it.
Right.
This is Minersville School District v. Gobitis. This is the 1939 Supreme Court case in which the court held 8-1.
8-1, okay? I mean, what's significant about this case, among other things, is the person who wrote the majority opinion, all right? And that person is Felix Frankfurter. If you think that anybody should be sensitive to the plight of victims of religious discrimination, you would think that somebody who is a progressive Jew, which Frankfurter was, he'd earlier been involved in defending, among others, Sacco and Vicente, all right, or at least arguing in support of them. You would think that someone like that would rally very strongly to the defense of Jehovah's Witnesses. No, went just the other way.
There's some interesting questions about the justices and their approach to Jehovah's Witnesses, because Jackson, who wrote the majority opinion in Barnett later, right? Which
vindicates the Jehovah's Witnesses' First Amendment claim, and has some of the most incredible language ever written in a First Amendment opinion.
Mm-hmm. But Jackson was kind of prejudiced against the witnesses.
Oh, yes, kind of prejudiced. I mean, he had written in earlier opinions, that these people are troublemakers. He didn't use that word, but something to that effect. So if you had to pick a person who was going to write an opinion reversing Gobitis, because Gobitis is reversed just 3 years later, in the Barnett case where Justice Jackson writes the majority opinion, you certainly wouldn't have thought that Justice Jackson would come to their defense. Moreover, Zachariah Chafee, a noted First Amendment scholar, the man that really kind of, if you will, aided and abetted Justice Holmes in terms of developing First Amendment theory in 1919 and thereafter, and the prominent Harvard scholar. If you look at his treatise, he really dismisses the Jehovah's Witnesses as just, a kind of a sidebar, a bunch of, if you will, troublemakers who are a nuisance. It isn't until later in the Barnett case that he begins to have a change of heart, as did Justice Jackson.
What were the facts in Gobitis?
Well, they're very similar. I mean, young students, I believe, today what we call middle school, there was a requirement that students, and this was particularly during the war. Remember, this is 1939.
The United States hasn't entered the war yet, but the Nazi power is...
Yes, right. But that sentiment is there, and it's going to go from 1939 to 1943. So by that time, the United States does enter the war. And it was just to call it a requirement, which it was, but it was just so much a part of the custom that young people, students, middle grade students 10, 12 years old, would just at the beginning of the day stand and pledge allegiance. This was just kind of like...
I had to do it when I was in school.
Yeah, and you didn't...
I think they still do it.
Yeah, and you weren't questioned, and you weren't told, now, Johnny, you have to stand up and what have you. It was just kind of the norm. So when somebody, on religious reasons, refused to do that, this was just seen as hostile toward the government, being seen as unpatriotic. And the students would be suspended or even expelled. So it was a pretty serious matter, and the case went to the Supreme Court, and it had argued free exercise of religion, and they lose, with Justice Frankfurter writing the opinion for the court. And, it seems strange to us today, but in those days, it was not. And after the court rules against Gobitis, I believe 44 states had...
48 states.
48 states, yes, which was, I guess, all that was in the Union at that time. 48 states had either old laws or new laws that compelled pledging allegiance to the flag, and the vast majority of them, the penalty was expulsion.
Yeah. Well, if you have any question as to how Supreme Court decisions can shape the culture, there was effectively a civil war against Jehovah's Witnesses as a result of this case.
Basically, the case said it's open season. When Gobitis came down in 1939 and denied their First Amendment claims and said, yes, you can discipline, suspend, or expel these students, it was open season on Jehovah's Witnesses.
Yeah, there was something like 20,000 Jehovah's Witnesses who were expelled from school as a result of this because it was against their faith to salute the flag. But you have 48 states that passed these mandatory flag salute
Which
laws.
meant that there was no public school that they could go to.
Yeah.
Right? I mean, if you were expelled from one public school, you're not going to be admitted to another public school for doing the same thing. So they either had to pay to go to private school or they didn't go to school.
Yeah, they were being run out of town. There was one Southern sheriff who you quote, who told a reporter why the witnesses were being run out of town. He says, quote, "They're traitors. The Supreme Court says so. Ain't you heard?"
Yeah. I mean, it's a very dark period. I mean, we talk about the McCarthy era, which is in the 50s, but in the 40s, the animus toward Jehovah's Witnesses was just enormous. And as I said, it got so bad that the Attorney General, Francis Spittle, a man of conscience, by the way, a former law clerk, then called secretaries to Justice Holmes, felt the need to go on national radio and call for toleration and calm. I mean, it was that bad.
So what happened at the court to go from an 8-1 decision saying that mandatory flag salute laws are constitutional to just a few years later getting the Barnett decision, which says they're unconstitutional?
Well, I think what happened is that while we're in a war fighting Nazis and people of conscience saw what was going on against the Jehovah's Witnesses, how bad it had become. I mean, I'm just speculating here, but I think that hostility really got some people to stop and think about the wisdom of that decision, because the facts are essentially the same. I mean, they're very similar. I mean, there's nothing significantly different in terms of the factual record between the two cases. And as I said, you have people like Justice Jackson doing a 180-degree turn in the Barnett case. A turnaround compared to how he had voted earlier, and some of the concurrent opinions he'd written, chastising the Jehovah's Witnesses.
And in the Barnett, as you mentioned earlier, you get some of the most glowing language in defense of free speech and free conscience of any Supreme Court decision
that's ever been written.
Ever been written. You get Jackson writes, I can't remember it verbatim, but he essentially says if there's any fixed star in our constitutional constellation,
right.
It's that no official high or petty can mandate what is essentially orthodox in religion. Or
pretty good, yeah. And it's just an incredible line, and it just shows how when the window of the mind opens up and perceives an injustice, sometimes against all odds, the world changes. And Hayden Covington, although he didn't argue the first case, a fellow named Rutherford, who was a legal counsel then, argued that case along with a Harvard law professor. That was the Gobitis case. But when it comes to the Barnett case, Hayden Covington is there in his green suit, his red plaid tie, 6 feet tall, pretty close to yelling when he's speaking to the justices. And it's a new day. But it's a new day when it comes to the flag salute, because the Jehovah's Witnesses cases will continue to come to the Supreme Court.
Yeah, what were some of the other major First Amendment cases that Hayden C. Covington argued that established new precedent, good precedent, as we might say at FIRE, for the First Amendment?
Well, I mean, for example, what constitutes state action under the First Amendment? There was just a case before the Supreme Court this term. In other words, how much private action, when infused with some government action, becomes what we call state action, enough to apply the Constitution to particular forms of discrimination. Jehovah's Witnesses, in terms of picketing, all right, association, when it comes to, I mean, there were all sorts of things. I mean, like I said, a lot of picketing cases, a lot of assembly cases, a lot of solicitation cases, distributing literature. There were some cases that were brought in terms of when can somebody speak in a particular area, like a public forum, So whenever there was an opportunity to prosecute and persecute the Jehovah's Witnesses, and again, remember, Covington had picked the communities where they wanted to bring the challenges. He had orchestrated, with the clients what sort of conduct they would engage in to trigger prosecution. So he was very careful in the variety of cases that were brought to the Supreme Court. By the way, a lot of free exercise. We're talking about the speech cases, but there was a lot of free exercise cases. Freedom of religion today, like I said, if you take Jehovah's Witnesses out of the equation, there's just a big gap. And it's amazing today, people of faith, whether or not they be Christian, Jewish, Muslim, what have you, I think everybody's on board in terms of defending the principles the Jehovah's Witnesses fought for. But it wasn't true in the 30s and the 40s and the 50s.
Covington said of their efforts to change the law with regard to many First Amendment rights, as you mentioned, exercise, press, assembly, speech, of course, that these witnesses who were plaintiffs in these cases were writing their faith into the law.
Right. And it's a bit exaggerated, but there is a measure of truth to it. The writing faith into the law, all right? It was there. It just needed to be buttressed.
Yeah, I think the quote would be better if he said, writing the freedom to practice your faith into law. Right. Because the law doesn't only apply to Jehovah's Witnesses or their tenets of their faith.
I think he actually meant the former, but in terms of what was actually being done, I think you're right. The latter is true. By the way, I wanted to mention his name, Hayden, derives from the German Heiden, which means heathen. Mm-hmm. All right. So by name, he was a heathen. It's really incredible that a man who spent his life defending religious freedom, that his name should derive from a German word meaning heathen. Yeah.
Which probably derives from a Latin word.
Right.
It's, I guess German's not anyway. He wasn't successful in 15% of the cases, he argued, in front of the Supreme Court. And there's one very notable one, which is the Czaplinski case, which created essentially the fighting words doctrine, which many of us in the First Amendment community hate, although it's not often applied. This is the case in which a Jehovah's Witness who's essentially mobbed by anti-witness activists, people seeking to bring violence upon these witnesses, and the witness seeking police protection that wasn't being provided to them, calls him a goddamn racketeer.
Yeah, there were a number of situations where mobs attacked Jehovah's Witnesses and police just stood idly by. There were a number of instances where they broke it up, obviously, but there were other instances where they didn't. And sometimes that led to quote-unquote fighting words.
Whereby a witness yells at a police officer.
Right.
Do something.
Right. In colorful language. Not obscene language or anything like that, but nonetheless. And so, yes, and the fighting words doctrine, he loses that case. Fortunately, the fighting words doctrine today is the doctrine more in theory than in practice. Mm-hmm. Now that because there's any variety of ways. Today a person can approach a police officer and say a number of things and not be charged with quote unquote fighting words.
But the idea behind the fighting words doctrine is you say something that a reasonable person just couldn't control themselves and might fight you, might attack you as a result of your saying that thing. Did the police officer actually attack Czaplinski in this case? Do you remember?
They did, yes. In fact, by the way, fighting words, a typical situation is when you're in a bar and a guy next to you is 300 pounds and has tattoos and has a Harley T-shirt. And
you say something about his mom.
Yeah, right. Sitting right next to him at the bar. Right. Yeah. Those are fighting words. There's also whether or not the state prosecutes you or not, it's not a very smart thing to do. But that's the idea. And it starts with Czaplinski. He lost that case. But there weren't many that Hayden Covington lost. And it's just it's an incredible story about a remarkable man who did have his own demons. yes, he worked those 18 hours, but, as his life plays on, it doesn't continue to be as wonderful and as wondrous as it had been in the 30s and the 40s and the 50s and even a little part of the early 60s.
Yeah, he had a problem with drink.
He did. He, I think it's fair to say he was an alcoholic. It caused problems with his family. It caused problems with his church. He went and attacked the leader, or whatever they call the chief figure of the Jehovah's Witnesses at the time. He openly attacked him. I mean, by tact, I mean verbally attacked, not physically attacked. He had this real drinking problem. The problem is that by the 60s, he no longer had any clients.
Because he'd won.
He'd won all these.
He was a victim of his own success.
Right. And there was nothing, he couldn't get a job at a firm. And he really wasn't very successful as an individual lawyer out there hustling for cases. And so here he had, by the way, his pay in those days was just enough to kind of pay the bills and what have you. It wasn't like he was making a lot of money. He never made a lot of money. So when the Jehovah's Witnesses cases are over, he's out of a job. He really doesn't have anything to do with his life. He's becoming increasingly an alcoholic to the point where it becomes chronic. There's disputes within his family. He's attacking the church, and he's effectively expelled. And then, of course, before that happens, he's representing Muhammad Ali at a trial level. This is where Muhammad Ali is contesting being drafted into the military during the war, the Vietnam War, and he's doing so on religious conscience grounds. And Hayden Covington really kind of blows the trial.
Makes some bad arguments.
Yeah. And didn't cross-examine as many witnesses or as well as he should have. But by this time, he's just out of it. I mean, he dies at 67, so he's not that old of a man. But toward the end, he's basically unemployed. His family is broken up. He's a chronic alcoholic. He's expelled from the church. Things look pretty bad there toward the end. Just before, not long before he dies, they bring him back into the fold. I think they see that death is knocking at his door. And he fades away into oblivion. And for decades and decades, nobody knows the name Hayden C. Covington. And to this day, he remains unknown. I hope, I sometimes fantasize about, because there's more to be said about Hayden Covington. There's been books written on the Jehovah's Witnesses. There's been a few books written about them and their struggle for religious freedom. But almost a whole book could be done on Hayden Covington. But so this article is something that I had started collecting information on years and years ago. And, time permitting, I may someday do a book on him. But I just, for the time being, wanted to get his name out there in the world of legal scholarship in terms of people who are teaching First Amendment law. Yeah,
you write at the end of your piece, the past, after all, lives only in the memories of the living.
Yeah.
Who remembered Hayden Covington that brought him to your attention? Or did you just happen to see his name on Supreme Court briefs?
I was working on putting together some materials for my constitutional law class. And as I was going through these various Supreme Court opinions, I noticed the name Hayden Covington kept coming up again and again and again. And so I worked with my library, our librarians, and we did some research. And I found out, much to my surprise, that this fellow had argued an enormous number of cases, a significant number of cases in the Supreme Court. And so I started doing research. And really, I mean, over the years, either alone or with David Scover or with Sam Chaltain, I've tried to pick people who've made important contributions to First Amendment law, but are off the kind of the radar screen. So Lenny Bruce, Lawrence Ferlinghetti, Benjamin Gitlow. I mean, from Gitlow versus New York, Charlotte Whitney, as in Whitney versus California, and there's another person, Robert L. Carter. I mean, who knows the name Robert L. Carter? Robert L. Carter. He was second in command. Now, it's just so happened that the guy who was first in command was so significant and cast such a a long shadow that you didn't see the number 2 guy. The number 1 guy was the chief counsel for the NAACP, Thurgood Marshall. But the second guy in line was a fellow named Robert L. Carter. Robert L. Carter had argued a number of First Amendment cases before the Supreme Court on behalf of the NAACP, and one of them was called NAACP versus Alabama, decided in 1958. And there, the doctrine of freedom of association. So if you look at the text of the First Amendment,
association isn't there.
It isn't there. There's assembly there, there's petition there, there's speech there, there's press there, there's exercise there, and there's no establishment there, but there's no assembly, no freedom of association. And so Robert L. Carter, after he graduated from Howard Law School, a person of color, African American, had applied to Columbia Law School where he got an LLM, and he wrote his dissertation on freedom of association. That dissertation, by the way, remains unpublished. I have a copy of it, and I would like to publish it along with an introduction to it. But in any event, the idea of freedom of association, it didn't come from the Warren Court. They needed somebody to bring the case before them and to conceptualize for them, and that person was Robert L. Carter. So there are these figures over the years that either alone or, as I said, with my co-author David Scover or with Sam Chaltain, with whom I wrote We Must Not Be Afraid to Be Free. There was a chapter in there on Benjamin Gitlow. There was a chapter in there on Robert L. Carter. Something in there as on Charlotte Whitney as well. So these are people that have made important contributions. So much of our law is court-centric and judge-centric. It just focuses on the judges as if, these cases just magically come before them, and that the people who bring them or the people who are actually involved in them, Benjamin Gitlow, Charlotte Whitney, Lawrence Ferlinghetti, Lenny Bruce, they somehow kind of vanish and become insignificant.
Unless they become Supreme Court justices like Thurgood Marshall Justice Ruth Bader Ginsburg.
Right. And so what I've been trying to do all these years is give some airtime, because the First Amendment isn't just what judges write about. The First Amendment is what the people do with their rights. And they may be as individuals, Lenny Bruce, Charlotte Whitney, Benjamin Gitlow, Lawrence Ferlinghetti, or they may be the lawyers, Hayden Covington or Robert L. Carter.
Yeah. You say there are a couple just kind of practical reasons why our understanding of the law or appreciation for the law, our revere of certain figures in the law is judge-centric. You say because for most of time up until recent history, it was just hard to find out about these lawyers because you'd get the decisions, but you couldn't access the briefs unless you had access to a specialized library. The internet didn't always publish them. Now SCOTUS blog is very good about making clear and FIRE's First Amendment library also talks about the lawyers. But it was very hard as a law student to get this information.
And so it's not taught in law schools. It's not taught in colleges. In fact, most of the editions, including the official edition of the Supreme Court reports, at least as first printed now, don't list the names of the lawyers. They not only used to list the names of the lawyers, they used to, I guess prior to 1943 or something right about there, there'd be summaries of the lawyers' arguments in the Supreme Court that were actually printed in the official record. That's all gone now. I think the only place online that mentions the name of the lawyers is Oyez. Yes.
SCOTUS blog doesn't do it?
No. When they list, if you go to the trial transcript, the transcript for moral arguments, they do.
Yeah.
But in terms of the opinions, no. Those are on Justicia, and I don't believe they list the names of the lawyers there.
Well, another reason is that you write in your article, because I should mention your article it begins with a discussion about the paucity of litigation scholarship about litigators, and then uses that as a segue to talk about one litigator about whom very little has been written, Hayden C. Covington. But another reason you give is that a lot of law professors are never actually practicing lawyers. I mean, they're lawyers, of course, but they spend their time in the academy or as clerks and then go straight into the
and so their view of the world of constitutional law is what judges write. So, for example, if you ask any law professor, well, where does the commercial speech doctrine come from? And they will say, and I would say 99% of them would say this, it comes from the Virginia pharmacy case, and the idea came from Justice Harry Blackmun, the author of that opinion, and before that, in some language in the Bigelow case, Bigelow versus Virginia. Well, that's not quite accurate. It came from a group called the Litigation Group, which was a Nader group, a Ralph Nader group, a consumer group, a progressive group, arguing on behalf of the First Amendment. And so the doctrine, commercial speech doctrine, really begins with a lawyer named Alan Morrison, who's now at George Washington Law School, and is thereafter, and he wins he argued, I guess, in the Bigelow case, and then in the Virginia pharmacy, where the doctrine is actually launched. He was the lawyer who brought that case, and successfully so. And thereafter, years later, with David Vladeck, now of Georgetown Law School, the First Amendment doctrine really develops in significant ways because of these lawyers, all right? And so to say that, it was Harry Blackmun is part of the story, but the really important part of the story that's left out of the equation. It could be David Vladeck, it could be Alan Morrison, it could be Robert L. Carter, it could be Hayden C. Covington, it could be, any number of people. I mean, it's rather interesting. When I did the book with Sam Chaltain, We Must Not Be Afraid to Be Free, we were kind of fascinated to find out that the same lawyer who argued Gitlow versus New York also argued Whitney versus California, Robert Nels. And who remembers him? He was a law clerk to a fellow on the State High Court of New York, a fellow named Cordozo. He wasn't a law clerk. He worked in Cordozo's law firm. That's right. And then Cordozo goes on to the court, and Robert Nels argues Gitlow and Whitney. I mean, it's really rather significant. And when Nels dies, I believe Zachariah Chafee writes in The Nation magazine, we've lost one of our great defenders of civil liberties. But who knows? Who remembers Robert Nels? Who remembers Hayden Covington? Who remembers, any of these people? And more recently, as I said, you have all of these folks who play a significant role, like Alan Morrison, like David Vladeck, and they're just left out of the picture.
Yeah, well, let's take your call of action by way of closing here. Who are the First Amendment litigators today that we should know? You write in your article about James Bopp, who is, they call the Terre Haute, who's responsible for a lot of the campaign finance law.
Yeah, if you look at campaign finance law and you look at the cases that come to the Supreme Court that started in lower courts, the name that keeps bopping up, and I
pun intended.
Yeah, a little. But whatever one makes of the views espoused by James Bopp, he's a significant player. He deserves to be recognized. He also litigates a lot in the area of abortion that is a quote-unquote pro-life. But he's definitely a player in the world of campaign finance, and yet, very few people.
Part of that's probably because he lives and practices out of rural Indiana. Well, Terre Haute's not really rural, but it's a small town, small city.
But still, you start. I had done a book with David Scover on campaign finance, When Money Speaks. And when we were kind of going through all those campaign finance cases, James Bopp, it's just amazing how often that name came up. There was a defamation case that had gone to the Supreme Court involving Johnny Cochran. Johnny Cochran was suing for defamation, and there was a First Amendment defense that had been raised, a First Amendment defense against the claim of defamation. And the case was briefed and all ready to go in the U.S. Supreme Court. And there was a fellow who's now the dean of University of California School of Law at Berkeley, Erwin Chemerinsky. Now, as it turned out, that case was mooted by his death. But there's all
not
these...
by Chemerinsky's death.
No, not
Chemerinsky's still around.
No, but by Cochran's death.
Okay.
By the way, when Cochran was a younger man and a prosecutor, he was one of the people that prosecuted Lenny Bruce. Right.
Wow.
So it's just kind of amazing. So the history, the culture of the First Amendment is more than just what judges write. It's what lawyers do, it's what people do, and it's that idea, that portion of the First Amendment's history that sometimes alone, sometimes with David Scover, sometimes with Sam Chaltain, and forthcoming now with Bill Creeley and Dave Hudson and Jackie Farmer, we're trying to kind of broaden the historical lens to include these other important figures.
Well, Ron, I think we'll end there. Again, as Ron writes, the past, after all, lives only in the memories of the living, and we'll do our best on this podcast to feature some of these First Amendment litigators. We do a pretty good job. We bring a lot of litigators on the show and talk about their work and its effect on the rights that we use every day. So, Ron, thanks for coming on the show. What should we plug before we head out of here? First things first, you're upcoming.
Coming next year, Robert Corn Revere. I believe the title of the book is The Mind of the Censor and the Eye of the Beholder, coming out in Cambridge University Press next year. Bob, forgive me if
I didn't know he was writing a book. Wow,
he is. He's well into it. I've seen portions of it. It's very exciting. Robert Corn Revere, a very noted First Amendment lawyer. I believe the book will be coming out next year. As I understand it, he's going to be finishing it at the end of this year, and it'll be coming out next year. But I've read a couple of chapters, and there's a lot of history in it. And if the name Anthony Comstock means anything to you, wait until you read Robert Corn Revere's forthcoming book. So if I can plug that, he's a very noted First Amendment lawyer.
He's been on this podcast a few times.
Yeah, and he has a book coming out next year.
Well, thank you, Ron. For those of you who want to check out Ron's article in the Florida International University Law Review, it came out in the spring 2019 edition, and it's called Thoughts on Hayden C. Covington and the Paucity of Litigation Scholarship. And
it's available online for free.
Yes, it is, and I'll link it in the show notes here. This podcast is hosted, produced, and recorded by me, Nico Perrino, and edited by Aaron Reese. To learn more about So to Speak, you can follow us on Twitter at twitter.com/freespeechtalk. You can like us on Facebook at facebook.com/so-to-speak-podcast. And you can also email us feedback or questions at so-to-speak@thefire.org. I ask you every episode, if you enjoyed this show, please consider leaving us a review on Apple Podcasts or Google Play, wherever you get your podcasts. Reviews help us attract new listeners to the show. And until next time, I thank you again for listening.